A very warm welcome to everyone. Myself Madhurima Bose. Today my presentation topic is Public International Law versus Municipal Law. First of all, we need to know what is international law. The legal system governing the relationship between nations, more modernly the law of international relations, embracing not only nations but also such participants as international organizations and individuals, such as those who invoke their human rights or commits war crimes. So next is what is municipal law. The ordinances and other laws applicable within a city, town or other local government entity. Thus municipal law is the acts made by the legislature or the law-making authority of a state applicable to that state alone. So next is difference between international law and municipal law. So first, international law is largely but not altogether concerned with relation among states, whereas municipal law controls relations between individuals within a state and between individuals and the state. The second difference is international law, on the other hand, regulates relations between member states of the family of nations, and another side, municipal law regulates relations between the individuals under the sway of the respective state and the relation between the state and their respective individuals. So third point is law of nations is a law, not a verb, but between sovereign states, whereas municipal law is a law of a sovereign other individual subjected to his will. So there is some theories like monism, dualism, specific adoption theory, transformation theory and delegation theory. So basically, what is monism theory? The exponents of this theory emphasizes the scientific analysis of the internal structure of law. Monists hold the international law and state law share a common origin, namely law. According to monists, law is a unified branch of knowledge, no matter whether it applies on persons or other entity. So next is dualism theory. Dualism theory was developed by a German scholar Treppel and an Italian scholar Anzilotti. In the view of the dualistic writers, international law and state law are two separate laws. The important principle of dualism is that international law and municipal law are two separate and distinct orders in their objects and spaces of operation, such that the norms of one would not operate within the realm of the other without a positive act of reception or transformation So the international law and municipal law are two entirely different things, and the international law can never be applied in the state without incorporating or transforming it into municipal law. The subject of municipal law is primarily individuals and groups, and that of international law is states. The main function of municipal law is regulating internal functioning of the state, relation between the state and the individual. And the function of international law is to supervise the relation between states. Third is specific adoption theory. According to the exponents of this theory, international law cannot be directly enforced in the field of state law. In order to enforce it in the field of municipal law, it is necessary to make its specific adoption. International law can be applied in the field of municipal law only when municipal law either permits it or adopts it specifically. So for example, International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights have been adopted in India under the Protection of Human Rights Act. So fourth is transformation theory. According to the exponents of this theory, for the application of international law in the field of municipal law, the rules of international law have to undergo transformation. International law undergoes transformation as it spreads universally. Unless transformed, it cannot be applied to municipal law. States incorporate treaties and norms into their municipal law by specific transformational devices. Delegation theory. According to this theory, the constitutional rule of international law permit each state to determine as to how international treaties will become applicable in the field of state law. International law delegates the rule-making power to each state accordance with the procedure and system prevailing in each state in accordance with the Constitution and rules of the Treaty of Convention the member states sign and agree. Now it's time for conclusion. International is no longer law between nations, it also embraces individuals. International law gradually headed towards a human commonwealth encompassing individuals, state and other aggregate cutting across state boundaries. Thank you.